नमस्ते, आपका कंपनी 360 के यूट्यूब चैनल में स्वागत है और ये वीडियो आपके सामने प्रस्तुत हो रहा है ILMS अकेडमी के द्वारा, जो इंडियाज़ प्रीमियर लीगल एंड मैनेजमेंट एजुकेशन पोर्टल है. Get certified to enhance employability.
And today's topic is admissibility of electronic evidences in India. The 21st century saw a technological revolution which enthralled not only India but the whole world. The use of computers is not limited to established organizations or institutions but available to every individual at a swipe of a finger. इंफॉर्मेशन टेक्नोलॉजी ने हमारी हर एक एक्टिविटी को बहुत ईजी कर दिया है. आज के साइबर वर्ल्ड में जहाँ पर हम कंप्यूटर्स का अधिक से अधिक इस्तेमाल करते हैं, वहाँ टेक्नोलॉजी के ग्रोथ को भी बहुत बढ़ावा मिला. एवोल्यूशन ऑफ इंफॉर्मेशन टेक्नोलॉजी gave birth to the cyberspace wherein internet provides equal opportunities to all the people to access any information, data storage, analyze, etc. with the use of high technology. This increasing reliance on electronic means of communications, e-commerce and storage of information in digital form has most certainly caused a need to transform the law relating to information technology and rules of admissibility of electronic evidence both in civil and criminal matters in India. The proliferation of computers and the influence of information technology on society as a whole, coupled with the ability to store and amass information in digital form, have all necessitated amendments in Indian law to incorporate the provisions of the appreciation of digital evidence. The Information Technology Act 2000 and its amendment are based on the United Nations Commission on International Trade Law, Model Law on Electronic Commerce. The Information Technology, that is the IT Act 2000, was amended to follow for the admissibility of digital evidence. An amendment to the Indian Evidence Act 1872, the Indian Penal Code 1860, Bankers Book Evidence Act 1891 provides the legislative framework for transactions in electronic world. With the change in law, courts have developed case law regarding reliance on electronic evidence. Judges have also demonstrated perceptiveness towards the intrinsic electronic nature of evidence, which includes insight regarding the admissibility of such evidence and the interpretation of the law in relation to the matter in which electronic evidence can be brought and filed before the court. Digital evidence or electronic evidence is any probative information stored or transmitted in a digital form that a party to a court case may use at trial. Before accepting digital evidence, it is vital that the determination of its relevance, veracity, and authenticity be ascertained by the court, and to establish if the fact is hearsay or a copy is preferred to the original. Digital evidence is information of probative value that is stored or transmitted in binary form. Evidence is not only limited to the found on computers but may also extend to include evidence on digital devices such as telecommunication or electronic multimedia devices. The e-evidence can be found in emails, digital photographs, ATM transaction logs, word processing, documents, instant message histories, files saved from accounting programs, spreadsheets, internet browser histories, databases, contents of computer memory, computer backups, computer printouts, global positioning system tracks, logs from a hotel's electronic door locks, digital video or audio files. Digital evidence tends to be more voluminous, more difficult to destroy, easily modified, easily duplicated, potentially more expensive and more readily available. मैंने अब तक इलेक्ट्रॉनिक एविडेंस के बारे में बहुत बात की है, और अगर आपको इसका मीनिंग जानना है तो वो मैं आपको बताने वाला हूँ. The type of evidence that we are dealing with has been variously described as electronic evidence, digital evidence, or computer evidence. The word digital is commonly used in computing and electronics, especially where physical world information is converted to binary numeric form as in digital audio and digital photography.
Definitions of digital evidence include information of probatory value stored or transmitted in binary form, and information stored or transmitted in binary form that may be relied on in court. हम देख सकते हैं कि डिजिटल ये टर्म बहुत वाइड है, जबकि बाइनरी जो वर्ड है वो बहुत रिस्ट्रिक्टिव है, क्योंकि वो सिर्फ एक फॉर्म के डेटा को डिस्क्राइब करता है. इलेक्ट्रॉनिक एविडेंस, इसका मतलब है डेटा that is comprising the output of analog devices or data in digital format that is manipulated, stored or communicated by any man-made device, computer or computer system, or transmitted over a communication system that has the potential to make the factual account of either party more probable or less probable than it would be without the evidence. This definition has three elements. First, it is intended to include all forms of evidence that is created, manipulated or stored in a product that can, in its widest meaning, be considered a computer excluding for the time being the human brain. Second, it aims to include the various forms of devices by which data can be stored or transmitted, including analog devices that produce an output. Ideally, this definition will include any form of device, whether it is a computer, as we presently understand the meaning of a computer, telephone systems, wireless telecommunication systems, and networks such as the internet, and the computer systems that are embedded into a device, such as mobile telephones, smart cards, and navigation system. The third element restricts the data to information that is relevant to the process by which a dispute, whatever the nature of the disagreement, is decided by an adjudicator, whatever the form and the level the adjudication takes. This part of the definition includes one aspect of admissibility, relevance only, but does not use admissibility in itself as a defining criteria, because some evidence will be admissible but excluded by the adjudicator within the remit of their authority, or inadmissible for the reasons that have been nothing to do with the nature of the evidence, for instance, because of the way it was collected. The last criteria, however, restricts the definition of electronic evidence to those items offered by the parties as part of the fact-finding process. आज हम देख सकते हैं कि ई गवर्नेंस में बहुत ज़्यादा ग्रोथ हुई है, चाहे वो पब्लिक या प्राइवेट सेक्टर हो या कोई भी ई कॉमर्स एक्टिविटी हो। इसीलिए इलेक्ट्रॉनिक एविडेंस कम्युनिकेशन, प्रोसेसिंग और डॉक्यूमेंटेशन के लिए एक फंडामेंटल पिलर के रूप में इवॉल्व हुए हैं। The government agencies are opening up to introduce various governance policies electronically, and periodical filings to regulate and control the industries are done through electronic means. These various forms of electronic evidence or digital evidence are increasingly being used in the judicial proceedings. At the stage of trial, judges are often asked to rule on the admissibility of electronic evidence, and it substantially impacts the outcome of civil lawsuit or conviction or acquittal of the accused. The court continue to grapple with this new electronic frontier as the unique nature of evidence, as well as the ease with which it can be fabricated or falsified, creates hurdle to admissibility not faced with other evidences. The various categories of electronic evidence such as CD, DVD, hard disk or memory card, database, data, website data, social network communication, email, instant chat messages, SMS or MMS, and computer-generated documents poses unique problem and challenges for proper authentication and subject to a different set of use. With this, the first part of this topic comes to an end. To understand this topic deeply, you can take the certificate course on electronic evidences given by ILMS Academy. This course gives you a detailed overview about what are electronic evidences, how to procure electronic evidence and details thereof. तो इसी के साथ ये वीडियो समाप्त होता है। Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST and more. Get certified to enhance employability. Thank you for watching this video and have a nice day ahead.